We're already streaming, just so you know. What I was going to have the parties do is read into the record all the documents and then move them at once. Okay, you ready? Okay. We are on the record. This is case number 9725 in the matter of the application of Chaberton Solar Pine Rock LLC for a certificate of public convenience and necessity to construct a 3.0 megawatt solar photovoltaic generating facility in Carroll County, Maryland. Let's start with appearances, starting with the company.
Good afternoon, Your Honor. My name is Andy Flavin with the law firm Troutman Pepper Hamilton Sanders, here on behalf of the applicant Chaberton Solar Pine Rock LLC. And if I may also enter the appearance of Mark Macklin and Victoria De Las Casas as well.
PPRP.
Good afternoon, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program. I'd also like to enter the appearance of Steve Towson, and that's spelled Stevetalson is the last name.
OPC.
Good afternoon, Your Honor. Isaac Lindenbaum on behalf of the Office of People's Counsel.
And staff.
Good afternoon. Harrison Scher on behalf of the technical staff of the Maryland Public Service Commission.
Mr. Flavin, did you want to start with any exhibits?
Yes, please, Your Honor, if we may.
Oh, I guess, yeah, I'll note for the record that I received your settlement status indicating that Chaberton Solar is agreeing to all the conditions set forth by staff in its testimony and the recommended licensing conditions filed by PPRP. So there, as my understanding, there's no dispute between the parties, so that we're going to enter in the exhibits without any objections being taken.
Yes, Your Honor, that's correct.
Okay, so if you want to read in, I have pulled up your exhibit list that you circulated. If you want to read those items into the record, please.
Yes, thank you, Your Honor. For number one, and I believe this was a little bit out of order chronologically, but I believe we reserved Exhibit 1, the certificates of publication for the pre-hearing conference, which were filed on May 2nd, 2024, under mail log number 309442. That's 9 pages long.
Yeah, that should have already been entered in at the pre-hearing conference.
Thank you, Your Honor. Now, we respectfully ask that the cover letter and certificate of service for the application, which was filed on February 23rd, 2024, under mail log number 307804, and is 5 pages long, be marked and admitted.
Okay, why don't you read all of the exhibits?
Okay.
And since there's no objection, I will stop you if I have a question, otherwise.
Certainly.
Read them all and then.
Thank you, Your Honor. For number 3, can we please mark the petition, which was filed on February 23rd, 2024, also under mail log number 307804, and that's 9 pages long.
So marked.
May we please mark as number Exhibit 4, the verification of Michael J. Doniger, filed on February 23rd, 2024, under mail log number 307804, and that's only 1 page.
So marked.
Thank you, Your Honor. May we please mark as Exhibit number 5, the application appendix, filed on February 23rd, 2024, under mail log number 307804, and that's 16 pages long.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 7, Attachment A to the application, which is correspondence with Carroll County, filed on February 23rd, 2024, under mail log number 307804, and that's 2 pages.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 7. Attachment B, which is the environmental review document, filed on February 23rd, 2024, under mail log number 307804. That's 25 pages long.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 8, Attachment C, which is utility interconnection correspondence, filed on February 23rd, 2024, under mail log number 307804, and that's 4 pages.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 9, ERD Appendices 1 through 6, filed on February 23rd, 2024, under mail log number 307804, and that's 605 pages.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 10, the ERD Appendices number 7 through 17, filed February 23rd, 2024, under mail log number 307804, and those are 156 pages.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 11, the update to the Maryland Department of Environment, or MDE, Tier 2 Anti-Degradation Review, filed March 11th, 2024, under mail log number 308164, and that's 7 pages.
So marked.
Thank you, Your Honor. May we please mark as Exhibit 12, the revised petition, filed on March 14th, 2024, under mail log number 308429, and that's 11 pages.
249.
I'm sorry, yes, I'm sorry, 308429.
No,
Oh, I'm sorry, 249.
Yes.
I apologize, I'm sorry.
that's okay. That's marked as Exhibit 9. No, I'm sorry, Exhibit 12.
Thank you, Your Honor. May we please have marked as Exhibit 13 the responses to the PPRP's data request 1 in the public version, filed April 2nd, 2024, under mail log number 308711, and that's 79 pages.
So marked.
And, Your Honor, we also have a confidential version of that. How would Your Honor prefer to have that numbered?
We will, you have it separately here?
Yes, Your Honor. It's listed at number 14 on the list.
I don't want to, I mean, usually we do the same number with a C, but
Okay.
that would change your whole numbering system. So it's fine the way you have it.
Okay. Understood. Thank you, Your Honor. May we please have marked as Exhibit 14 the confidential version of the responses to the PPRP's data request 1, which are filed on April 2nd, 2024, under mail log number 308711, and that's 79 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 15 the updated attachment 1-6 for the JEDI, J-E-D-I report in the public version, filed on May 16th, 2024, under mail log number 309714, and that's just 1 page.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 16, the confidential version of the updated attachment 1-6, which is the JEDI, J-E-D-I report, filed May 16th, 2024, under mail log number 309714, and that's also just 1 page.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 17 the direct testimony of Ryan Boswell, filed June 21st, 2024, under mail log number 310389, and that's 7 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 18 the direct testimony of Andrew Reese, filed June 21st, 2024, under mail log number 310389, and that's 19 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 19 the certificates of publication for the virtual public hearing, which were filed on June 26, 2024, under mail log number 310438, and that's 12 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 20 the revised conceptual site plan, filed October 2nd, 2024, under mail log number 312642, and that's 17 pages.
Can I ask a question? Didn't it get revised again? So there, isn't there another?
Yes, yes, Your Honor. It's part of Mr. Boswell's supplemental testimony.
So you really want the intermediate revised conceptual plan as an exhibit?
If Your Honor doesn't think it's necessary based on the updated revised version, we're happy. I mean, we don't think it's necessary, but.
I would like to avoid confusion as well. I'd rather call out the final, at least as of this hearing, conceptual site plan.
Certainly, Your Honor.
Called out
We don't need to enter in that.
So 20 will, I mean, it'll be marked, but it's not going to be admitted.
Understood. Thank you, Your Honor. May we please have marked as Exhibit 21 the certificates of publication for the second public comment hearing, which were filed on October 3rd, 2024, under mail log number 312677. That's 13 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 22 the sign affidavit from the second public comment hearing, which was filed on October 10th, 2024, under mail log number 312826, and that's 6 pages.
So marked.
Thank you, Your Honor. May we please have marked as Exhibit 23 the supplemental testimony of Ryan Boswell, which, just for the record, includes the most up-to-date conceptual site plan for the project. That was filed on October 11th, 2024, under mail log number 312845, and that's 21 pages.
So marked.
Thank you, Your Honor. And finally, may we please have marked as Exhibit 24 the settlement status update, which was filed on October 18th, 2024, under mail log number 312987, and that's just 2 pages.
So marked. So Chaberton exhibits 1 through 19, and then 21 through 24 will be entered into the record.
Thank you, Your Honor.
PPRP, let me pull up your, you sent me a list too, didn't you?
Yes, Your Honor. I sent the corrected one yesterday afternoon as well.
I see attachments 2 and 3. Oh, and corrected exhibit. Okay. Okay, go ahead.
Okay, if I could have marked the following exhibits on behalf of PPRP. PPRP Exhibit 1 would be the direct testimony of Sean Seaman. It was filed October 3rd, 2024, mail log number 312689, consisting of 27 pages and 1 appendix.
So marked.
PPRP Exhibit 2 is a secretarial letter dated September 10, 2024, and mail log number 312689, 1 page, also filed on October 3rd, 2024.
So marked.
PPRP Exhibit 3 is the initial recommended license conditions, consisting of 9 pages, also mail log number 312689, filed October 3rd, 2024.
So marked.
PPRP Exhibit 4 is the project assessment report for the Pine Rock Solar Project, mail log number 312689, consisting of 33 pages, filed October 3rd, 2024.
So marked. I have a question. Are you going to be filing a revised? Yes.
Yes, Your Honor. I have that at the end, but I can include it as Exhibit 4A if you would prefer that.
No, just wanted to make sure. Okay, go ahead.
PPRP Exhibit 5 is the PAR Appendix A, the applicant responses to selected PPRP data request, also mail log number 312689, filed October 3rd, 2024, consisting of 69 pages.
That'll be marked as Exhibit 5.
PPRP Exhibit 6 would be the PAR Appendix B, which is the glare analysis, mail log number 312689, consisting of 24 pages, October 3rd, filed on October 3rd, 2024.
That'll be marked as PPRP Exhibit 6.
And PPRP Exhibit 7 is the PAR Appendix C, the Environmental Justice EJ Screen Report, which is mail log number 312689, consisting of 73 pages, filed October 3rd, 2024.
So marked.
PPRP Exhibit 8 is the PAR Appendix D, which is reference sections of PPRP's websites, mail log number 312689, filed October 3rd, 2024, consisting of 27 pages.
So marked.
PPRP Exhibit 9 is PPRP Response to Bench Data Request number 1, mail log number 312897, consisting of 8 pages and 1 attachment, entitled Forged Solar Glare Analysis, consisting of 24 pages, and it was filed October 15th, 2024.
Okay, you lost me. Can you repeat that?
Yes, Your Honor, and I did include additional information last night, so that might be what is throwing you off. But PRP's response to bench data request number 1, which was filed October 15th, 2024, it has 18 pages, and it also has an attachment, which is the Forged Solar Glare Analysis.
Okay, so you want 9 to be the response and all the attachments?
Yes, Your Honor.
Okay, so marked.
PPRP Exhibit 10 is the supplemental direct testimony of William Cotton. It was filed on October 22nd, 2024, under mail log number 313039. It consists of 10 pages and an appendix.
So marked.
PPRP Exhibit 11 is attachment 2 to the supplemental direct testimony of William Cotton, and one which is the Forged Solar Glare Analysis, consisting of 26 pages, dated October 2024. It was filed October 22nd, 2024, and the mail log number is 313062.
Oh, October 20. Okay, 2024. Yes, so marked.
PPRP Exhibit 12 is attachment 3 to the supplemental direct testimony of William Cotton. It's also the Forged Solar Glare Analysis, dated October 2024, consisting of 23 pages. It's under mail log number 313062, and it was also filed October 22nd, 2024.
So marked.
And also, I would like to request that I don't know if you'd prefer me to do this when Mr. Cotton is on the stand, or if you'd like me to do it now, but to mark, leave the record, a request that leave the record open to be able to provide the revised portions of the PAR that address the portions that are impacted from the supplemental testimony of the applicant.
Yes, we can leave the record open. We may even have an additional hearing if necessary.
Okay, thank you, Your Honor. And so PPRP Exhibit 13 will be the revised sections of the project assessment report for the Pine Rock Solar Project, a clean copy of that. And PPRP Exhibit 13A would be the revised project assessment report for the Pine Rock Solar Project, a red-lined copy of that.
Okay, I can't mark what doesn't exist, but I know that you anticipate filing those.
Thank you, Your Honor. And with that, those are all our exhibits.
Okay. PPRP Exhibits 1 through 12 are entered into the record. All right, OPC does not have any exhibits. Okay. Staff.
Thank you, Your Honor. Staff has one exhibit, the direct testimony and exhibit of Roger F. Austin, filed on October 3rd, consisting of 17 pages under mail log number 312703.
Okay, that'll be marked as Staff Exhibit 1 and admitted into the record. Okay. I have some questions starting with Mr. Boswell. Can you swear me?
Please raise your right hand
do.
Please state your name, spell your first and last name, and give us your business address.
My name is Ryan Boswell, RyanBoswell. Business address is 1700 Rockville Pike, Suite 305, Rockville, Maryland.
Thank you.
Did you have a chance to review Mr. Cotton's supplemental testimony in this case?
I did, Your Honor.
So he noted a discrepancy in the site plan having to do with the landscape buffer in the northwest corner of the limit of disturbance.
Yes, Your Honor, I'm happy to address that discrepancy.
Okay, so is Chaberton proposing for it to wrap around the corner or end just along for the buffer to be along Sullivan Road and stop, or wrap around the corner of that driveway?
We're proposing for the buffer to wrap around the corner. Sheet 3 of the latest site plan filed with my supplemental testimony accurately portrays our intentions there. The discrepancy arises because we have multiple engineering groups working on the design.
Sorry, you said which sheet accurately reflects it?
It's the sheet that's labeled Sheet 3.
So the one that's labeled 01 is not accurate.
That's correct, Your Honor. The sheet labeled 01 is not accurate.
See, M101, sheet 1, sheet 2, sheet 3. Okay. So sheet 3 reflects the landscape buffer in green on that sheet?
That's correct, Your Honor. That extension around the corner there was put in place to satisfy some concerns about the neighbor directly to the north and east of that corner of the LOD. They expressed some concerns that when the foliage falls off the trees, the existing vegetation, that they may be able to see the array, and so we agreed to extend the landscape buffer to address that concern.
So in this area, there's some gray shading on the plan. Do you know what that is?
Let me review the plan, please. I believe, Your Honor, that the gray shading is meant to illustrate steep slopes in that area.
Okay, so the landscape buffer appears to be right in the middle of the steep slope. Would you agree?
That's correct, Your Honor.
And that's feasible?
It's certainly feasible, Your Honor. It may not lead to the greatest effectiveness, but the landscape buffer can be planted on those slopes.
Wouldn't it work better at the top of the slope?
I do agree it would work better at the top of the slope. It's a bit difficult to tell if there's a conflict with the fence line, but we'd be happy if we have the space to pull in the fence line and bring the landscape buffer closer up the hill to the top of the slopes.
I mean, that's your fence, right?
That's correct.
Okay, and then the landscape buffer at the southern edge. Along the access drive. That was always there, right?
That's correct, Your Honor.
Extends from Sullivan Road to about where the landscape yard drive is.
That's correct.
Do you know, in looking at this map, whether, I guess to the east, on the adjacent property, are those solar panels?
Your Honor, I'm not aware of solar panels on the property to the east. There are solar panels on the property where the landscape supply,
I
Westminster.
guess you might say south.
Yes,
Those are solar panels.
Yes, Your Honor.
Owned by I guess, the Bowmans?
I believe, Your Honor, that they serve the business there, the landscape supply.
Okay. It's not a community solar.
You're correct, yeah.
According to the application at page 5, Chaberton expected to receive and execute an interconnection agreement within approximately 12 to 18 months. That would put it somewhere between February of 2025 and August 2025. Is that still what Chaberton expects?
We do expect to receive the interconnection agreement within that time frame. Based on what we know today, probably on the earlier side of that February, March time frame.
And the application appendix at page 9 states that the land on which the project is proposed is used for agricultural purposes with crops such as soybeans and corn. At least one person at the public hearing commented, or it might have been in a written comment, talked about the impact of a solar facility on this land as impacting our food system. Are the soybeans and corn being grown on the site currently, are those crops for human consumption or for feeding farm animals, if you know?
Your Honor, as far as I'm aware, those are commodity crops that are not directly for human consumption.
Do you know if there's livestock on the site?
I have not seen livestock on the site. I've only seen corn grown on the site.
Do you know if there's livestock nearby? On adjacent parcels?
I'm not aware of any livestock on any adjacent parcels.
Okay. Do you know if corn and soybeans need to be transported off-site to be processed?
I do not know that for a fact, but I would expect that they are processed off-site.
So you don't know if there are any feed mills in Carroll County?
I'm not aware of any.
But that doesn't mean there aren't. You just don't know. Either way.
I just don't know, Your Honor.
So the Board of Carroll County Commissioners filed a letter in the docket dated May 30, 2024, in which the commissioners state that the Carroll County zoning code allows all types of solar in the commercial and industrial zoning districts. Did Chaberton investigate whether there was any commercial or industrial land available in Carroll County that would have been suitable for this project?
We did not investigate those as an alternative to this project. I have investigated the availability of land in those zoning classes. To give some perspective, while there are 138,000 acres of agricultural land in Carroll County, there are fewer than 5,000 acres zoned industrially, and there's a fraction of that zoned for commercial purposes.
So do you know of any efforts that the county has undertaken to provide opportunities for solar development in commercial and industrial areas?
Beyond the zoning code allowing for it, I am not aware of any efforts by the Carroll County government to expand solar in those zones.
So your direct testimony at page 4, you cite to the Climate Solutions Now Act of 2022 and the target therein of 60% reduction in greenhouse gas emissions by 2031. And also you cited Governor Moore recently issued an executive order directing the Maryland Energy Administration to establish a framework for a clean energy standard to achieve 100% clean electricity in Maryland by 2035. And then at line 8 on page 4, you state, these prudent and aggressive goals cannot be achieved through an approach that restricts deployment of solar facilities to rooftops, parking lots, and industrial parks. Why is that?
Your Honor, by the governor's own solar task force, they issued a final report estimating that about 25,000 to 35,000 acres of farmland would be required to reach the current RPS goal, which is 14.5% electricity generated from solar. So even less aggressive than the goal set for 2035. That constitutes about 2% of the ag land in Maryland. And in their analysis, arriving at that number, they assumed that at 60% of that being ground-mounted solar, that would be 25,000 acres required. If Maryland follows a national trend, which is generally about 80% ground-mounted solar, that number goes up to 35,000 acres.
So the 25,000 to 35,000 acres in farmland needed to achieve the 14.5% solar carve-out, do you know where the other amount is coming from?
I'm sorry, to clarify, they assumed a 60-40 split where 60% is ground-mounted, 40% would be rooftop and carports.
According to the ERD, the project will displace 4,464 tons of CO2 emissions. Did you review the PAR?
Yes, Your Honor.
PPRP used, I guess, the AVERT tool, and they have a figure of 3,820 tons of displaced emissions. Can you explain the difference?
Your Honor, sometimes there are discrepancies in the amount of generation from the same size solar array. Because the AVERT tool does not take into account AC and DC ratios, our projects often generate more electricity than the baseline AVERT model assumes.
In the first public hearing, Chaberton representatives stated that you started your local outreach for the project back in January of 2023, including sending letters to neighbors of the projects, conducting neighbor visits, and we have had 2 community meetings for this project, one in February 2023 and another in January of 2024. Both were attended by several members of the community. Do you know how many people attended the community meeting in February of 2023?
Your Honor, in February of 2023, if I recall correctly, it was about a dozen members of the community.
Do you know where it was held?
It was at the Westminster Exploration Commons.
Do you know how many letters were sent out?
Your Honor, we sent out 21 letters, not including a letter to the landowner.
And so you have that list somewhere?
I don't have that list with me today, but we do have a record of who received those letters.
So the letters in January 2023 likely informed the neighbors of the upcoming community meeting. How were they informed of the second community meeting?
We subsequently sent additional letters, 3 additional letters prior to the meeting that was held January 11th, 2024. It was sent to the same list of neighbors, which were those properties that were at least within 300 feet of the property boundary.
You say within 300 feet,
That's correct.
but you said you sent out a dozen letters.
21 letters, Your Honor.
21 letters. There's not 21 residences within 300 feet.
That's probably correct, so I would assume then that we reached further than 300 feet from the property boundaries.
Is this outreach required?
I'm not aware of a requirement through the CPCN process. We may have been following Carroll County's guidelines at the time of their solar ordinance was in place. But as best practice, Chaberton notifies neighbors and hosts a community meeting regardless of whether it's required.
How's the project monitored once it's operational?
The project can be monitored remotely via a SCADA system to monitor generation, weather conditions, and any failures that may occur, modules that may fail or anything of that nature. There are also routine visits for maintenance purposes, both of the electric components and the grounds.
When you say routine, how often?
Typically about once a month.
But back to the remote monitoring, would that monitoring, because it's monitoring generation, pick up a broken panel?
That's correct, Your Honor.
And if it were to pick up a broken panel, what action, if any, would be taken?
A maintenance crew would be dispatched in response to a signal from the remote monitoring.
Where are Chaberton's maintenance crews?
We don't contract directly for the maintenance. As a developer, we tend to sell the asset to an independent power producer who would then contract directly with those maintenance crews.
Does Chaberton have plans to sell this particular project?
We do, Your Honor.
And who is it likely to sell the project to?
We haven't selected a buyer at this time, but we do intend to sell the project.
And that independent power producer would be out-of-state, in-state?
Most likely, it would be an out-of-state buyer with some in-state presence, but we have not begun the process of identifying potential buyers.
Okay, thank you for your testimony.
Thank you, Your Honor.
Your Honor, just one quick question.
Oh, sure.
If I may, and it's just talking with Ms. McLemore beforehand. I don't know if it would help to make clear on the record Chaberton's position regarding the proposed additional licensing condition that was offered by the PPRP in Mr. Cotton's supplemental testimony.
You want to say it yourself?
Yes, Your Honor.
Okay.
We don't have any concerns with that.
No concerns with the additional license condition? In other words, Chaberton would accept the additional license condition?
Yes, Your Honor.
Okay, you can step down.
Thank you.
Mr. Reese?
Raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Andrew Reese, ANDREWREESE. I'm with Arm Group LLC out of the Mechanicsburg office. That is at Suite 201 4600 Lena Drive. That is LENA, and then it's Mechanicsburg, Pennsylvania 17055.
I don't know if you listened to the public hearing that was held in Carroll County, but there was at least one person who commented, I guess they were referencing actually a project in Pennsylvania, but the concern expressed was that these panels actually have no ability to be disposed of. There's nowhere that they can be disposed of. I noticed in the decommissioning plan in the attachment A, an estimate of a round trip to the landfill of distance of 16 miles. So that would indicate to me that there's a landfill that will accept the panels and other equipment within 8 miles of the project. Is
Correct.
that correct?
Yes.
Do you know what that facility is called?
I'd have to look that up. I prepared a couple for the application, but I can confirm I did call the local landfill myself personally and confirm that they would receive the materials and that the materials would either be taken to that facility and then taken to a transfer station or would be and recycled, or the materials that could not be would be landfilled.
Okay, thank you.
And I could follow up or look on my phone here and provide the name here in a couple of seconds.
Okay,
It's just
yep.
off
I
the
don't
top
think
of
any
my
of
head.
us are in a hurry,
All
except
right.
for PPRP, who's been here since 9:30.
Thank you.
Your Honor, if I may just grab the binder that's up there.
Sure. While he's looking on his phone, Mr. Seaman, I'm going to ask Mr. Seaman some questions. And go ahead. And when I get to a point where they're really for Mr. Cotton, you just let me know.
Okay.
All right. And then,
Mr. Seaman probably.
What's that?
When he
Yes.
gets to questions for
while he's looking, you can go ahead. Northern? Do you want me to swear him in, or can you do that? Connie? We have a new witness. That's okay.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Sean Seaman, spelled SHAWN SEAMAN. I work for the Department of Natural Resources located at 580 Taylor Avenue in Annapolis, Maryland.
Mr. Seaman, do you believe that with incorporation of the recommended license conditions into any CPCN that might be granted by this commission, the project can be constructed and operated in accordance with all applicable environmental laws and standards and in such a way as to minimize environmental impacts?
I do.
If DNR or MDE believed that the project would result in unacceptable environmental impacts, would they recommend that the commission approve the project?
No, I'm sorry, can you say that again?
Sure. If
Yeah.
DNR or MDE believed that the project would result in unacceptable environmental impacts, would they recommend that the commission approve it?
We would not recommend that unless those environmental impacts could be mitigated in some fashion. I'm trying to, do you understand my answer?
DNR
Sorry.
and MDE would not recommend approval unless the impacts could be mitigated.
Correct, yes.
Your direct testimony at page 5, you state that the 16.8 acres of prime farmland, which is 90% of the 18 acres of this project, is less than 0.02% of the prime farmland in Carroll County. Does that mean that there are approximately 84,000 acres of prime farmland in Carroll County?
Without a calculator, I can't do that math off the top of my head, but yes, that seems about right. So what we're trying to say here is that 16.8 acres is only 0.02% of the available prime farmland within the county.
Okay. Yeah, no, I did the math with a calculator.
Okay.
Before today. I got 84,000. And I guess if 84,000 is prime farmland, I took your testimony to mean that there's more than 84,000 acres of land that's zoned agricultural, but 84,000 is the acreage that's prime farmland. Would that be a correct interpretation of your testimony?
I wouldn't need to double check that, I'm sorry.
Okay, you can.
Because the way I'm sorry, go ahead.
That's okay. I was going to say you can double check and get back to me. We're going to hold this record open.
Yeah, because the way it's worded in my testimony is less than 0.02 of the prime farmland within the county. But that may have been a typo. I would need to double check.
Okay. Did you agree with witness Boswell's statement regarding the differences between whatever tool that Chaberton uses and the AVERT tool as far as the metric tons of CO2 emissions being removed?
Yes, I didn't run that tool myself. Witness Cotton may be able to elaborate on that additionally. I'm not sure. His company did that. But it's not often. It's often that we find small differences when we run those tools.
So at page 14 of your testimony, you talk about the habitat for some wildlife. Identified potential habitat for the monarch butterfly and also the bog turtle. just wondered what happened with that identification of that potential habitat.
So that comes out of the Fish and Wildlife Services IPAC system, and there's potential for that habitat. And really all that's doing is stating that based on their system, they have identified that potential habitat.
So what happens after the identification?
We condition that, and if there are RTE species identified during construction and operation, then that condition would apply.
So then starting on page 15, you're talking about the visual quality and glare. And the maturation of trees and shrubs planted in the landscape buffers will reduce the visual footprint of the project over time, although the natural topography of the surrounding area limits the effectiveness of the buffer. I drove out there. I think what you mean, it's kind of rolling topography? Yeah. Okay.
Correct. If you want me to elaborate,
please.
The majority of the proposed development site is a higher elevation. It's a hill, and it's higher than things like Sullivan Road and that private entrance to the landscaping facility.
So in the PAR, the response to bench data request 1 referenced figures 4 and 5. Are larger copies of these available somewhere?
I could get you larger images.
That would be great.
Okay.
At this size, I wasn't able to discern any difference between year 0 and year 3.
There's not much, yeah. And I just want to clarify. So you're talking about visibility analysis year 0 and year 3.
Yes.
0 in blue, and I think year 3 in purple. Yeah, we'll get you larger images. I do agree with you. There's not a lot of difference. I think in the I'm not sure if north is oriented up in that picture, but
I would hope
if
so.
it is, what would I'm sorry.
It is.
Okay,
It's
so
clear.
I noticed some reduction in visibility on the southwest corner, but I would agree with you that it's not a lot overall.
And wouldn't this need to be redone with the change in the access drive?
It may be. That's why we're keeping that. We asked to keep the record open to make changes to the PAR.
Am I correct that if I have specific questions about glare, I should ask those of Witness Cotton?
Yes. Thank you.
Page 21 of your testimony, you start talking about noise and EMF, and you stated that the operational noise generated by the project is expected to be well below ambient background noise levels. Therefore, the project will have no significant impact to residential receptors. EMF levels from the project are not anticipated to pose a potential health risk to nearby residents. EMF levels from the proposed project are projected to fall below the threshold for human health standards at a distance of 10 feet. Someone commented, I think it was in the written comments, about the risk to farm animals from noise and EMF. Does PPRP do any analysis of the risk to farm animals, or is it limited to human?
So this is referencing a lot of historical studies. I'm not sure if any of them included farm animals, but we did a site visit on somewhere, I think that June 24th, I believe it was, and I did not observe any farm animals or anything that would support that type of agricultural business. It was literally just an open field.
I think several of the commenters talked about the impact on property values. Can you address that in your?
I sure can, yeah. And on our website, we have a section on property values that will explain this in detail. There have been multiple studies across the nation in the last decade or so that have looked at this, and some of them had no impact to property values, and some had what I would call minimal impact on property values, something in the range of 1 to 2%. But no, we haven't seen anything where there's what I would call a significant decrease in property value as a result of solar farms.
What about is one of the reasons to hold the record open is dealing with traffic impacts on Sullivan Road with the new access road?
That's one of the reasons, yeah. So we identified 3 areas of the PAR that we need to look at again after this. One of them was glare, one was visibility, one was transportation. So, and you know, we need to probably revise all those sections, yes.
And you're going to revise the license conditions, correct?
Yes,
Because they still reference the site plan filed on October 2nd.
yes.
So license condition 20 is a landscape maintenance agreement. And it indicates that Chaberton Solar Pine Rock shall file a copy of an executed landscaping maintenance agreement in the docket. Who is a party to that executed landscaping maintenance agreement?
I'm not sure if I understand the question. What,
Okay,
Yeah.
I understand that the project, well, I actually don't understand, because it says Chaberton Solar Pine Rock shall file a copy, and then it talks about the project owner,
right,
which I would think would be Chaberton Solar Pine Rock.
yeah, I think that's what, sorry.
But,
go ahead.
so the project owner has sole responsibility for the maintenance and replacement of dead plantings. Who else is signing this? Who's this agreement with? Usually agreements with more than one person.
Right. So are you trying to drive at this, that they're going to sell the property?
No.
Oh, okay.
I'm trying to understand how this agreement is enforceable. Do you have a sample? Has this been done in other cases?
I mean, I don't have a sample with me. I could certainly look into that and see what's been filed in other cases. This is
Just from reading this, I don't understand who's signing it and what it says exactly.
right.
I guess the beneficiary is Carroll County, but I'm guessing.
So my understanding is what this condition is asking for is the owner. Let's just say the owner, right? Because Chaberton just testified that they intend to sell this property. So
Right.
the owner would enter into an agreement with a landscape maintenance company to ensure that all the landscape buffers are maintained, and then file that in the docket on this case.
Okay, so the agreement would be with the project owner and a landscape maintenance company.
Right.
Okay, yeah, I'd still like to see a sample.
Okay. And I can give you some background if you'd like. Early on these solar projects, we noticed a trend where developers were planting trees and not essentially taking care of them, watering them, maintaining them, and then the trees either died off or did not grow according to our plans, and then they did not provide the visual screen or the buffer we intended. So we came up with this condition to make sure that the owner cannot just walk away, that they have to maintain those landscape buffers.
Okay. But then in condition 21, it's Chaberton Solar Pine Rock must file in the docket a copy of an executed surety.
Yep.
There's no indication of timing on that. So theoretically, Chaberton Solar Pine Rock could sell this project, and then that condition would be sort of rendered useless.
Yeah, that's great input. Yeah, I would like to add a timing component to that.
And do you have an idea of amount?
I do not.
And how would that process be? How would we determine the amount of cash or bond that needs to be?
Yeah, it's so what we've done on decommissioning, and it's just is a relevant example, is we've actually verified what has been presented to us, like cost for recycling, things like that. So we would take the same approach on this, cost of tree replacement, cost of watering, things like that.
So something needs to happen
Yes.
after.
Yeah.
Okay.
I would agree. So if they propose a bond amount, there needs to be some kind of verification of that to make sure that it would cover any work that was needed to be done.
What does PPRP envision with the complaint resolution process in condition 22?
Right. So this is a relatively standard condition for us. It provides a condition that allows other folks, adjacent property owners and others, to file a complaint. This is in there regarding reflective glare, visibility, things like that, as well as fugitive dust, road damage, and noise. As an example, if there were visibility issues from adjacent property owners, they would have this complaint resolution process in place that they could file a complaint with the Public Service Commission. We feel like it gives the public an opportunity after the project is built to voice their opinion on screening and things like that.
So the initial complaint would be filed with Chaberton based on, or the project owner, based on the address that's on a sign that's on the property.
Correct.
And then Chaberton or the project owner is then to provide the commission with a copy of the complaint and its response within 30 days.
Correct.
And I guess if the aggrieved party is not satisfied with the project owner's response, they can file a complaint with the commission.
Yes.
That's what you have?
Yes.
Okay. The bond you spoke of related to decommissioning. If we go to that section. If you don't know, I can talk to your attorney, but is it your understanding that that bond has to do with decommissioning only?
Correct.
So there's no other money to available. There's the landscape surety, and there's which would be used to plant new trees or provide irrigation.
Right.
And then there'd be the decommissioning bond to take care of decommissioning, but there's no other monies for resolving complaints, correct?
Correct.
In the glare analysis and potential mitigation license condition, under C, it says if the results of the glare analysis identify that the final panel type, array design, tracking technology, or layout has materially changed the project's glare profile, Chaberton Solar Pine Rock shall submit. As determined by whom?
As we intend to, I'm sorry, can you give me that number just so I can?
Oh, yeah.
actually, yeah.
It's 23.
Okay, thank you. Sorry. And you said C,
Yeah, I mean, feel free to read them all.
right? Right. So the intention of this condition is we've discovered on previous projects that often, almost always, these projects are conceptual in nature, and often in the realm of like 15% drawings. So in order to be able to address glare later on with actual components being used rather than proposed in a conceptual manner during the CPCN process, we've added this condition. So essentially, what we often see is that what the CPC or the application, the layout, the components used, and things like that in the application are often not what actually happens during construction. So we see that as a significant change. So if there's any significant changes like that, then we ask the applicant to rerun the glare analysis based on what's actually being built.
Yes. That's A, right? That's subsection A. They've selected a final panel type, panel design, and tracking technology other than that incorporated into the CPCN. So under A, they have to perform a comprehensive glare analysis.
Right.
Okay, and then B, they file it.
Right.
And this still has to be 60 days prior to the start of any construction.
If there's significant changes between the conceptual layout and components used and what is actually being used at the time of construction.
Well, there's no qualification put on the requirement that they file a comprehensive glare analysis. Just 23 at the beginning says, if Chaberton Solar Pine Rock selects a final panel type, panel design, tracking technology, or layout other than that incorporated into the CPCN. So that's going to be any, according to your testimony, they're going to have to file an updated glare analysis.
Typically, yeah.
Right. So they're going to do that under A. And then file it under B, but they can do it up to 60 days prior to the start of construction. Then under C, if the results of the glare analysis identify that the final panel type, array design, tracking technology, or layout has materially changed the project's glare profile. Is that where PPRP is determining there's been a material change?
No, I think the applicant would tell us there's a material change, and then they would run the glare analysis. We would run our own independent glare analysis again, and then I think what you're driving at in C is that if needed, right, if there was unacceptable glare that needed to be mitigated, then we are asking to have the ability to revise our conditions in order to mitigate that potential risk.
What is meant by temporary mitigation in D?
Right. In some cases, we need temporary mitigation in order to mitigate glare while the trees grow to maturity. So that is essentially a catch-all that if there's temporary mitigation in place, that temporary mitigation cannot be removed until the natural mitigation, meaning trees, can essentially do their job.
Did Witness Cotton look at visibility in general or just glare?
Both.
Both.
I-
Thank you.
You're welcome. Thank you.
You don't want me to redirect or anything?
I do have one quick clarification on the first thing that you requested that we provide. Is that amount of acres zoned agriculture? You know, when you're requesting, we have the prime farmland indicated.
I think that Mr. Seaman was going to clarify his testimony, how it best be clarified.
So my intention is to give you both numbers.
That's great.
Okay? Yeah.
But that's zoned ag, correct?
Yeah,
Well,
Zoned ag.
it's both. He's going to give
Right,
us-
right,
I'm
prime
gonna-
and zoned.
Yeah, I'm going to go back. I'm going to give you amount of acres within the county zoned ag and amount of prime farmland within the county and a percentage compared to this project. I think that's what you're looking for, right?
Yes.
Thank you, Your Honor.
Thank you. Okay, you can step down.
Thank you, Your Honor.
Mr. Cotton, come on up.
Please raise your right hand. Do you solemnly affirm under penalty of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, spell your first and last name, and give us your business address.
William Cotton, that's William, Cotton, Cotton, Exeter Associates Incorporated, located at 10480 Little Patuxent Parkway, Suite 300, Columbia, Maryland.
Hi, good afternoon. So you probably heard my discussion with Mr. Boswell about the landscape buffer wrapping around the corner.
Yes, ma'am.
But that's really only a small, I guess, change in terms of visibility and glare,
That's
right?
correct.
But your testimony talked about a larger change on the other side, and I didn't understand that. I'm on page 5, starting on line 23, you talk about the changes introduced by the applicant in its revised site plan result in an overall decrease in predicted yellow glare of 47%. I don't understand. Just from changing the driveway from the shared, well, it's not shared, but the driveway, the access to the landscaping yard to Sullivan Road changes the glare by 47%?
That combined with other factors that we found. So we requested the shape files from the applicant to better understand the geographical layout of the new site plan. That obviously includes the change to the landscape buffer from the access drive, like you mentioned, on the western side of the LOD now to the northern side, which introduces a gap or changes the position of where that gap will be. That combined with there's slight panel configuration changes inside of the array field itself, which has changed really the total elevation of the project or some of the panels.
When was that change made?
During Mr. Boswell's, or I guess the site plans presented by Mr. Boswell,
From when to when?
that were filed on October 11th, 2024.
Okay, so the most recent site plan that we're working with, that's what you're talking about, introduce the changes, that you then analyze the glare, and there's less glare than there used to be.
Yes, that's correct.
Okay.
You can, I think the best way to visualize the changes and where the actual panels are located now between the initial site plan and this updated site plan is that there used to be berms located along the northern LOD in the initial site plan filed by the applicant. Those
Yes.
berms have been removed now in this new site plan, and that has also subsequently changed some of the panel layouts in those areas along the northern LOD. Those are also subsequently the some of the higher elevations compared to the southern portion of the array. So that impacts the level of glare being predicted in this case.
So I saw the berms before, but they weren't putting panels on the berms.
That's correct. No, they were not. They were putting panels in between the berms. If you compare the two side by side, you'll notice that there's a few locations where those arrays have now been moved. So the newer site plan is, I would say, more pleasing on the eye. It's more symmetrical.
Okay, I'm still trying to understand how the panels got, you said, lower in elevation?
Well, so considering the topography of the site, right, it's kind of a gently rolling hill, with the peak of that hill kind of being in the center of the project. Where the panels are now positioned, even though it's a slight modification, it does change the total elevation, at least what we input into the glare gauge model itself, which can change the plane that is modeled. So it can affect the estimate of glare, which is what we've seen in this case.
Okay, because at the top of page 5, you said that the most significant changes occurred in the northeastern and northwestern portions of the project where the applicant adjusted the buffer. But they didn't adjust the buffer. According to Mr. Boswell, it's still wrapping around. So that part of your testimony is, would you be updating that?
Well, as I described when I discussed the discrepancy in my testimony, and I apologize, Your Honor, I do not have it in front of me. The shapefiles are what we use in our analyses to get the most accurate representation of the geospatial coordinates of the site. Those shapefiles are more in line with that erroneous sheet of the filed update, right, where the buffer does not wrap around, it terminates, which Mr. Boswell discussed earlier. So what we have modeled in this case is based on the termination, right? The buffer does not wrap around that
And
northeastern corner.
You found that to create the most significant change.
That is a significant change in the site plan.
Okay, I'm trying to understand your testimony. The question is, do the revisions to the site plan provided in the applicant's supplemental direct testimony change PPRP's visibility analysis of the project? Your answer is yes, slightly. The most significant changes occur in the northeastern and northwestern portions of the project, where the applicant adjusted the buffer. So I guess I'm trying to understand first how that change is more significant than the drive at the other end, and also more significant than what you've just told me about how the arrays have been configured differently now.
Certainly, certainly. So there's a difference here, right? We briefly talked for a second there on glare. This question primarily is referring to the visibility analysis, and those are two different analyses. So here, the changes in the landscape buffer introduce the most significant changes to the visibility analysis.
And so when I look at figures 4 and 5 in the PAR for the visibility, can you see my screen?
Yes, ma'am.
So I see a lot of blue,
Mhm.
and you're talking that your analysis, you'd see more blue where there's not blue right here, closer to Beggs Road?
You see in the updated visibility analysis, you see that since the files that we've used that were provided by the applicant, the new shape files, they do not have that buffer wrapping around the northeastern corner.
Right.
you see increased visibility around that area of Sullivan Road primarily. Not so much on Beggs Road, which is why I said slightly. It's really a small change to the visibility of the project.
Okay.
And the same can occur or does occur on the northwestern corner, obviously, where
You call
there's
this
now
the
a gap.
northwestern corner?
The northwestern corner is, when I reference the northwestern corner, I mean essentially the intersection of the access driveway and Sullivan Road.
Okay. So it's not really terribly north.
Correct, yeah, it's
Okay.
more west.
All right, and then back to this one. So in current figure 4, shows the landscape buffer wrapped around, and so there's not a lot of blue between the driveway, I guess the person who owns the property's driveway,
Mhm.
between there and Beggs Road. You did an analysis without that piece because of it wasn't on the updated site plan, and so there would have been, if you had updated figure 4, more impacts in this area in the southwest quadrant of Beggs Road and Sullivan Road, correct?
If we have, so this is, what we're looking at is figure 4 from the PAR, based on the initial
Yes.
site plan. Okay. That northeastern corner of the project, if modeled with the buffer, decreases the visibility impacts.
Not from this, but
That's
in
correct. That's
general.
the year 0, right?
I'm just still trying
Yes, ma'am.
to, your testimony, the way it's worded is because, let's go back. It's worded the way it is because you didn't have this little piece of buffer perpendicular to Sullivan Road.
That's right.
Okay.
That's right, which increases the visibility to that section of the array.
So, to the extent we can tell anything from figures 4 and 5 at this scale, they're accurate.
Correct.
Now, at the other end, the west corner, they're not accurate because the drive has changed.
That's correct.
And would you clarify or describe that as significant or insignificant?
I would clarify it as insignificant. So yes, it introduces a change to the analysis, but it's an insignificant change.
But you had always had the buffer on the southern edge.
Yes, that is correct. However, it did have a gap where the entrance gate, 20-foot wide entrance gate, was for the site.
Was going to be.
Yes. So that that gap introduces increased visibility, obviously, from that gap in the buffer.
But
And now it is shifted to Sullivan Road instead. So
Yes.
you see, that's why I call it more or less an insignificant change. It just shifts that visibility profile a little bit more across Sullivan Road and onto that northern field area, as opposed to the access driveway and that western field area for the trees.
But with all this blue, this landscape buffer is not really doing anything.
That is the year 0 buffer, which essentially we model our year 0 at 0 feet height to make a worst case scenario as if the buffer was not there. That gives us the ability then, especially in cases like this where there are not a lot of changes introduced between the two figures, that gives us the ability to then showcase what an actual landscape buffer would look like in the year 3 estimation in figure 5. Does that make sense? I'm happy to explain it further.
No, it does. The only change I can see, really, and again, I know it needs to be revised because of the change in access drive location, is there's just a couple areas closer to the drive from which the project would not be visible.
That's correct.
But there's still a large area south of the project from which the project's visible because, again, it's on a hill.
Yes, that's correct.
One of the receptors was the owner of the project's driveway, which I believe is across from Beggs Road and then travels east of the project and then south of the project to their residence.
Yes.
And then just so I understand, when you provide hours hours of glare. I did some math. I know the number might have changed, but it was originally predicted that the Westminster Lawn Service Supply Yard building would receive approximately 29.5 hours of yellow glare per year. Is it accurate to say that that's about 5 minutes on an average day?
Well, actually, we don't need to do that math. The output of the modeling gives us that math. It actually shows us how many minutes per day on average is predicted to occur at that receptor location.
But you don't tell me.
Oh, I can tell you, yeah, I think
Okay.
I would like to refer to that report to get
Sure.
the most
Yeah.
accurate number. I don't
Yeah.
have it in front of me, I apologize.
That's okay. Do you have it
Um,
here?
I don't have a copy.
Is it? do I
Based
have it?
on memory judge, that is, it'll be around 30 minutes per day. That's taking into account both time periods, so the morning hours as well as the evening hours.
Is that something that is one of the appendices?
Yes, Your
Mhm.
It's going to be, I don't know which glare analysis.
Yeah, right in front of me, I have the one that you're looking at, Your Honor, I think attached to the PAR. That's appendix, what do we call it? Appendix B to the PAR. So that was obviously based on the initial site plans. So now that I have it in front of me, let me refer to what you just asked. There we go. So we're talking about stationary receptor labeled OP8. So what the prediction and what the model predicts to happen is that glare upon this receptor, at least initially, in our initial analysis, was predicted to occur between the months of April, sorry, it zoomed out, April to late August, primarily at the evening hours, actually all at the evening hours between 6 to 9 p.m. For a duration of less than 30 minutes. It is in 10-minute intervals, so to be precise, it's a little difficult, but I would say around 25 minutes maximum per day.
Okay. And so if I want to find the information you just recited,
Yes, ma'am. That is on page 20 of 48 or page 20 of 24.
I have one that's 26 pages. So toward the end.
Yeah, I would go to PDF page 21 of 49. Hopefully we're in the same document.
There's almost no chance. But I do see annual predicted glare, daily duration of glare. Is that what I'm looking for, these graphs
Yes, that's correct.
at each receptor?
That's right. That each receptor that is predicted to receive glare.
So, counsel, so we can be clear, you're going to revise the PAR. You're going to provide larger, updated versions of figures 4 and 5.
Yes, Your Honor.
I mean, the whole PAR will be revised, but then also,
Right.
so they'll be
Larger.
revised in the new PAR, but then also I'll get larger copies of them. And is the glare analysis, it sounds like it needs to be finalized again based on Mr. Boswell's testimony,
I will defer to Mr. Cotton, but I believe so.
because he didn't have it wrapped around.
That's correct. Yes, that's correct, Your Honor. I would like to add that I don't expect any significant changes that would actually impact our total conclusions here in this case. And that is based on the fact that we're not predicting glare at any stage to that northern and eastern area. But again, we would like to make sure that we have all the facts straight in our analysis. So we would like to reserve the right to rerun those one more time and provide those in updates.
Yes, and I'd like there to be a final.
Yes, Your Honor. The last minute revisions that impacted us, so apologies for that.
How do you go about comparing the visibility analysis to the glare analysis?
That's a good question. So they're two separate analyses, but we like to talk about them as being comparable to one another. They measure two different things. The glare analysis is really about, takes into account, the parameters of the site, as well as, the parameters of the receptors, but it leaves out a really important element, at least the details of that really important element. And that's the terrain change and topography of the surrounding area, as well as existing obstructions, such as stands of forests, sheds, houses, buildings, whatever. That's where the visibility analysis comes into play. We use essentially two models in our ArcGIS software. One, we start with it's called a bare earth model, which essentially is just the topography of the land, if you can imagine it, without anything on top of it, so that we have an established elevation for each point in our radius. Then we go about adding on the detailed canopy heights of all of the existing vegetation within the area. We try and get the best resolution possible for those maps. Currently, it's about 10 by 10 meters or 30 by 30 feet. And that gives us a very good idea of where in a radius around the project you will be able to see the project. That includes parameters such as observer height, which we typically use as 6 feet, indicative of an adult.
How do you get the height of the canopy?
That is, so for the bare earth model, we use USGS. They have a nice database with various resolutions. For the canopy, there is a 3-state model, I believe, developed by, we have it in our references, and I do not want to misstate the references. I think it's CHO. It is a database that's used, that's composited Maryland, Pennsylvania, as well as Delaware, so it's called the Tri-State Canopy Height Model.
Okay, sorry, I interrupted you. Do you remember the question?
Oh, I'm trying to remember where I was in the answer. Let's see. Yeah, so comparing those two analyses, right? So again, the observers we use, the observer height we use, and the visibility analysis is around 6 feet, indicative of a human. We use the top of panel height in this case, so that's about 8 foot. And then we also use the canopy heights in that area, right? And so essentially what the analysis does, the visibility analysis, is it puts the observer, that 6 foot tall representative person, around every point within the area of study around that. So usually it's a half-mile radius around the site, and it tells you if that person will be able to view the top edge of the panels from where they're standing. And that is obviously visualized in figures 4 and 5 of our PAR from the blue and purple regions. Those regions are indicative of where someone would likely see the project. We also, let me add, we also incorporate any features the applicant proposes, such as landscape buffers.
So you said the glare analysis doesn't incorporate terrain. So would you say the glare analysis is a worst case scenario?
Absolutely, yes. I think to add to that point, Your Honor, we like to try and model a worst case scenario to give us, obviously, if there were no trees or there were no buffers, right, what could happen potentially. To aid that worst case scenario development, we look at things like the lower panel height as opposed to the upper panel height. Glare usually occurs at a worse duration from the lower edge of the panels. So we model that. The model itself, the glare gauge model, it also has various assumptions, one of which is that clear skies occur every single day of the year. We just know that's not true. So that's another factor that adds into kind of a worst case estimate of predicted glare.
the proposed additional license condition is attached to his testimony? No.
It's in his testimony. It's towards the end. I'm sorry, Mr. Cotton can direct you to the page, I believe.
I see it.
Okay.
Page 9.
Yes, page 9 and 10.
Okay. Did PPRP do any analysis of, I guess, the original testimony, the way I read it was, the assumption was this is a commercial property, doesn't need any buffering. But was there any review done of how often the driveway is used or when the business operates? Anything more detailed?
No, only what we observed while on the site visit, which was minimal to no traffic to and from the site.
So you have the applicant shall, if requested by the owner of the Westminster Lawn Service Supply Yard, coordinate with the owner to identify and implement mitigation approaches to address glare impacts to the commercial structures and driveway on the property. What would those mitigation approaches be?
So we have, or I have detailed a few here in this testimony. You know, we referenced this to a case recently, the Backbone 2 amendment, where we also predicted yellow glare and a landscape buffer was not appropriate, and indeed it wasn't even available as an option. And even incorporating various different types of buffers, such as fences at various heights, we could not decrease the glare to zero, right, to erase the hazard and fully mitigate glare predicted. So in that case, we kind of developed this condition to allow the landowner to discuss with the applicant possible solutions, strategies such as placing a fence such as a 6-foot-tall wooden privacy fence, or a slatted chain link fence. And by slats, I mean obviously those fences with the plastic layers in between to try and occlude visibility to the site. Placing things such as that upon the landowner's property itself. So locating it closer to the access drive and to the facility itself to help mitigate.
But you do not know about the effectiveness of any of those measures, correct?
No, we have not modeled those.
The only thing you modeled was extending the landscape barrier all the way around the project.
That's correct. Yeah, locating it on the LOD around the project.
And can you go over the result of that?
Yes. So, like we discussed previously here at the beginning, there was an ultimate decrease that we saw from the initial proposed to this newly proposed site plan, right? That went from about 278 hours of total yellow glare predicted down to about 146 hours of total yellow glare predicted.
Mostly due to the change in configuration of the panels.
Correct.
Okay.
The main driver of glare remains the same. It's the access driveway, predicted to receive over 60 hours of yellow glare per year. When incorporating
Can I
a...
stop you there?
Oh, yes, ma'am.
60 hours of glare a year on this driveway that, do you know which, is it the driveway that runs more, not exactly parallel, but more parallel to Sullivan Road into the property? Is that the driveway you're talking about? Not the driveway that's being buffered, but once there's no longer any landscape buffer, the drive that comes off.
Correct, the one that cuts up to the supply yard itself.
Is that the driveway you're
Yes,
talking
that's
about?
that. We have modeled that entire driveway surface. It's called a root receptor, right? So it just takes the entire length of that driveway. But you can see where the glare is predicted to occur is along that portion that you have referenced there that cuts in, I guess, northward to the supply facility
Okay,
itself.
so that's the one that you're talking about now when you say the difference between the current plan and then a buffer along this let's say, eastern edge.
Correct.
Okay. And that, wouldn't you say that modeling a landscape buffer along that eastern edge would inform you as to the ability to mitigate with a fence on that person's property?
Yes, I do.
Okay. And so when you modeled that, you were going to tell me, I think, then about the reduction.
Correct. The reduction that you see is about 81%. So I would call that.
81% less glare?
That's correct. Right. I would call that a significant reduction. It does not, or I'm sorry, Your Honor. Let me repeat that. That 81% reduction is on the actual stationary receptor,
The building.
OP13, directly on that supply yard. For the access driveway, it's much less. It's about 21% reduction.
Okay. So you, is that because the driveway has length to it and the other stationary receptor is stationary? Or why is there such a difference in the ability to mitigate?
Right. Yeah. The driveway receptor does receive glare at various points along the driveway, whereas the stationary receptor obviously receives it at one point. It's also due to the way that the glare is predicted to occur from the panels themselves and where that glare actually does occur, or I would say predicted to occur, where that driveway sees kind of more glare towards the southern end as opposed to that facility, right? So the driveway is predicted to receive more glare than that facility, and it's predicted to receive less of a reduction of glare than that facility.
Okay. And the most, you said, what was the percentage of reduction if there was a buffer there?
If there was a buffer there, the access driveway receives a reduction of around 21%, and the
So do you know how many hours? of
I would
glare
need
that
to
equates
check my analyses. Give me one moment.
Sure, take your time.
Yes, so the reduction in the access driveway is from 63.2 hours of yellow glare
Per year?
to 45.4 hours of yellow glare.
And do you have then the minutes of an average day or?
Yes, correct. We could divide that. Right, that's taking the minutes and multiplying it by 60 to come up with hours.
No. It's 45.
Oh, I'm sorry, the duration per day, the minutes
Yeah.
per day. Yes, that will be, I don't have it in the testimony. That is in the attachments to the testimony.
Which are going to be updated.
Correct.
Okay. Right. I think that's all I have. Thank you.
Thank you.
No redirect.
One small question. Are you aware of any typographical errors in your testimony?
Yes. A small grammatical error, I believe, which caused some confusion earlier about that discrepancy where the buffer is along the, I call it the northeastern corner in my testimony. What page is that on?
I believe it's page 4.
Yes. Yes, on page 4, line 5, I'm talking about that discrepancy, and I state the landscape buffer located in the northwest corner of the LOD appears to be changed so that it no longer wraps around that corner a short distance. That should read the northeast corner of the site. Again, talking about that wraparound discrepancy.
Will you be submitting updated testimony? or
No,
just
Your
the-
Honor, and simply the only, I wasn't planning on it, simply the only thing that needs to be corrected instead of northwest.
No, not for that
it-
change. I'm talking about the hours.
Oh, the hours.
I thought the hours are going to change.
Could you clarify?
Starting on page 5, the percentage decrease and the number of hours. And, you know, even top of page 5 where he's talking about the buffer changing, it didn't change. So I think we need to correct.
Okay,
the
Your Honor,
testimony.
we can also provide that.
And then if any of the numbers changed, which I thought somewhere in here the numbers were going to change, because he talks about the stationary receptor. Maybe these didn't change, but
Your Honor, the results on that I discuss on pages 5, 6, and 7, those are comparing the initial analysis to the updated analysis based on Mr. Boswell's filed testimony. So
yes.
I do not,
So that won't change.
yes, I do not anticipate them to change. However, again, we do, like we talked about, we do need to rerun our visibility and glare analyses to make sure that we incorporate that landscape buffer correctly at the northeast corner.
Northeast corner, okay. So if there's any other changes in here, then you can file updated testimony.
So you would like us to update his testimony as well, is that correct?
Yeah, not
Okay.
simply because of the change from
I understand.
northwest, northeast, but
I understand.
the discussion of that. And then if there's any numbers, and maybe there's not, numbers related to that.
And larger figures.
Yes. Okay. I have a question for OPC. Did you, I think this was actually at the hearing in person, the public hearing. There were comments regarding the credit to subscribers being insufficient and that the project won't pay for itself. I think there were implications that this might end up costing ratepayers money. I didn't know if OPC had any response to those comments.
Not at this time, Your Honor, but if you would like, we could file something specifically responding to that question.
I would, please. Thank you. Staff, is there some reason that staff didn't conduct its own avoided emissions analysis in this case?
Not that I'm aware of with Your Honor, but I can follow up on that and get back to you.
The most recent case in Harford County, staff did its own climate analysis and avoided emissions analysis, and I didn't see that in this case.
Yes. Staff is currently contemplating that role in CPCN cases moving forward. So we didn't follow that type of testimony in this case.
Okay, as we mentioned, the record's held open. There may be a need for an additional hearing. I'll look for the additional testimony. Did you have a time frame? I think you did in your email.
Yes, Your Honor, we had a week, but I think it's increased. The amount of work we're going to be doing is increased. Can I confer with my client? and
About how
see
much time you need?
Yeah.
Yes, you can
Okay.
confer with your client.
Your Honor, by the 1st of November, November 1st.
All right, I'll look for that then. Anything else we need to deal with today?
Your Honor, just a quick logistical question. Based on that additional submission by the PPRP on or about November 1st, I assume when Your Honor decides that whether there will be an additional hearing necessary, that would also include whether you need us to provide any written confirmation that we don't have any objections to any conditions that may change or anything like that.
I don't think PPRP anticipates filing revised licensing conditions, do you?
If we did, it would not include anything except for the one condition that is included in Mr. Khan's testimony,
Okay.
the draft condition.
Okay, I appreciate the draft suggested condition. I'm not looking for that, for you to file that as part of the
Okay.
recommended licensing conditions in this case. I I wanted to, the initial response to the bench data request was that the landowner could file a complaint and there could be mitigation. I wanted to make sure that the mitigation was even feasible.
I understand, Your Honor.
Okay. So I think now we're done. Is that correct? Anybody have anything else? All right. Thank you, everyone. We're adjourned.